Walaikum wa barakatuh.
Prof. Okay, I think he's working on his slide.
Assalamu alaikum rahmatullah. Sorry, I thought I was I had unmuted. Jazakallah khairan, brother Ademola. I'm delighted to be back. A'udhu billahi minash shaitanir rajim. Bismillahir rahmanir rahim. Alhamdulillahi wa salatu wa salam ala man la nabi ba'da wa ali wa sahbi wa madabi dawati ila yawmi yubathun. Assalamu alaikum wa rahmatullahi wa barakatuh.
Wa alaikum assalam wa rahmatullahi wa barakatuh.
So on our topic where we left off, hopefully today we would have a little more opportunity to go into some nitty-gritty. But before we get to that at the tail end of our discussion today, we still have unfinished business regarding substantive issues on inheritance in Islam. We hopefully will end on the note where, depending on questions, I can make some suggestions on the issue of will making itself. Last week, as Bradamola was pointing out, we of course began the workshop on this topic on will and inheritance in Islam. And what we looked at briefly were the concept of milkiya, of the property. I said then, and I need to repeat it as a reminder to us, that the foundation of all this issue of being able to make a will or to talk about property, which we have and then which we want to leave behind, is that ownership of that property must be understood this as belonging to Allah. Inna lillah. We ourselves belong to Allah. Wa inna ilayhi rajiun. And we and everything we own, eventually the world, everything belongs to Allah and to return to Him. Lillahi mulku samawati wal ard. The beginning point which we have to keep in mind, which makes it easy for us to understand the Islamic perspective on will making and inheritance as things that go together, but need to be understood properly, especially because of the fact that our legal system is now being dominated by non-Islamic law, namely common law, is that in Islam, the concept of property is inherent in Allah. So once we understand that, it makes life easy for us. Then I talked about the inevitable. So if we have property, one thing is sure, whether we have property or not, whether we have position or not, whether we are rich or poor, whether we are president or the least powerful person, one thing is inevitable. We are all going to die. And then that leads us to the issue of al-wasaya, the will and testament in Islam, which we are ordinarily required to do. And I spoke about how it is that in exceptional circumstances, one should not make a will. But when I say one should not make a will, I mean in the Islamic sense. In fact, everybody should make a will, but the meaning of not making a will in the Islamic sense is that you don't give away your property and you leave all to your inheritors. And I said that should be the understanding when the person is poor. The person is not encouraged, in fact, in some circumstances, prohibited from giving out from the little that they already have. So one way to look at it is to give out when you are alive. The other issue then is what this ayah points out when we want to give out things while we are alive. We should give out. The best gift, Prophet ﷺ said, is when you are alive, strong, you need the wealth, and you are even afraid that if you give out some of it, you become, you feel it, you feel the impact of Prophet ﷺ, that is the best time to give. Allah said also that you don't start giving. If you decide to give while you are alive, you don't start giving out at the point of death. No, at that point, you can't. And that was what Sheikh Ahmad, I hope he's here today. Jazakumullah khairan for your contributions and observations last week, Sheikh. One thing Sheikh was pointing out that I also want to just point out today for clarity, because I've had some time in the last 1 week or so to give this lecture somewhere else. And they're also waiting for the part 2 to reflect on some things I would have loved to add in terms. And one basic thing is that distinction that Sheikh Ahmad mentioned when we talk about will, because we've been nurtured in the Western system and culture and way of looking at things. We should remember that Islamic idea of will prohibits us from even giving out or writing a will at the point when somebody is already at the doors of death or is in a terminal illness. Most scholars say that you cannot write a will then. So write a will now when we are well and good. And when you do, you also limit it to in giving out, making bequests, that is in giving out things, you only limit it to people who are not entitled to inherit from you, and secondly, to people preferably not more than a fourth of your property, and preferably not more than a fourth, but it's allowed for it to be up to a third. And the Sahaba, radiallahu anhum ajma'in, they actually were keen to emphasize that they prefer to give less than 1/4 and to give 1/5. Based on some understandings of some ayah of the Quran. This was the case with Ali ibn Abi Talib radiallahu anhu, amongst others, that you don't give out excessively, especially when you don't have much property to bequest. And the last is the rules of inheritance. And I spoke about certain principles. And those principles, one of them is that you cannot deprive somebody who is a lawful heir from inheriting you because you are not happy with them, for instance. It's one of the fundamental rules. You can't change the rules to suit your preferences and all of that. Okay, today, inshallah, we'll be looking, and hopefully this should take us a shorter period than the last one. Be looking at these further issues: disqualification from inheritance, distributing the inheritance, the principle of unlawful exclusion, and making a will, what I call practical issues, depending on the jurisdiction we are. I assume that most of us will be based in Nigeria, though I understand that there will be a few people also who may be in diaspora, as they call it, in the so-called abroad, probably in the US, Canada, or more likely the UK, and a few things to watch out for. But as I will say when I get to that, even though I'm qualified legal practitioner in Nigeria, I should point out that I'm now, and I've been, a law academic for well over a decade and a half. And if you are really wanting to know the state of the law, in terms of some practice or practical issues, you should consult a lawyer in all events. Anyway, as Sheikh Ahmad pointed out, I will say to us that this is not just about you sitting down in your room and writing, this is my will and putting it under your bed. In theory, that is legal, but whether it will be accepted to probate, i.e. whether it will be allowed to take effect, will depend a lot on the jurisdiction you are. So you had better make sure you see a lawyer. And definitely in Nigeria, you do need to see a lawyer. We have Muslim lawyers, amongst others, for instance. So there is no question here. And I want to assume some of them may already be on the platform and are actually members of H&H. And we have friends who are also lawyers that are Muslims. So that shouldn't be a problem. So let's start with this issue of disqualification from inheritance. Somebody asked me, the way to understand this is that somebody said something here, and then also at another lecture that I gave 2 days ago, I think that was on Christmas Day, that one of the reasons why I said people should make wills and let it be known that they have made a will, but one of the reasons why people don't like to let it be known that they have made a will or so is that some of the beneficiaries of the will, and somebody cited the case of husband who is ready to kill his wife in order to benefit from the will, or vice versa, or even a child or something. Somebody did raise this point as one of the reasons why people are coy about making it known that they have written a will. Now, that should not be an issue. There's a difference between making a will and telling people the contents of your will. And I'll come back to that. But it is very important that you make a will and let it be known that you made a will, and let at least somebody, especially one of the executors, know where you have kept your will. It's very important, because one of the things you should be able to do with your will is to specify that I want Imam Abraman Ahmed to be my executor. To be my to be the person to lead my janaza. I want Sheikh Abdul Rahim, Sheikh this or that. I can desire that. Your will is where to put it. But if you don't let anybody know you've made a will, or you've hide it so much, you'll have long be buried before it is read out that you wanted Sheikh Ahmad to be the person to lead your janaza. So this is why you should not mix up the issues about making a will and then hiding the fact that you've made a will, or hiding the will so much that it then defeats some of the purposes of the will. But that is just leading me to the point I want to make about disqualification from inheritance. Basically, this issue about that we find that people do because they want to benefit from a will do go on to murder the testator. Testator is the name of somebody who makes a will. Okay, murder the testator. Now, in common law, and I believe it takes this from the Sharia, and let's be honest, it's common sense. Sharia naturally is set on the nature of human beings, on the best nature of human beings, and also on the worst. Why? Because Allah knows us before He created us. It's set to capture what it is will be our inclinations from the fact that He knows us. Allah, who has created us, knows us. And so Sharia provided for this. And it is that it is odious. It is just so hateful that because you want to benefit from my will, you then kill me to benefit from it. So Sharia prohibits it, and common law to boot also prohibits it, that a murderer of the testator or somebody who has a hand in the murder of the testator should benefit from the will. So if a wife kills her husband, God forbid, in order to benefit from the will, then the wife will be excluded from the will in any event. Whether they kill the husband to benefit from the will or not, if you are a heir and you kill the person who made the will, you'll be excluded, not just from the will, but from inheritance. Because when we talk about will here, we're just talking about document. If you are a heir, you will not even, your name will be mentioned, but you will not be benefiting from what we call the will side of it, which is the bequest side, because you have a right, but you lose that right, apart from the fact that the person has to be prosecuted. So there should be understanding about that, that if you kill the maker of the will in order to benefit, or you kill the maker of the will for any other reason, you lose your right completely, automatically, from benefiting from it. Then the next person is a non-Muslim. These, I think, came up either here or on the second lecture. I think it's here on the issue of non-Muslims and benefits from the will. Islamic position is clear. Muslims inherit Muslims, up or down, son to parent, parent to son, brother to brother, sister to brother, sister to son, whatever, sister to sister, whatever. So non-Muslims are excluded from benefiting from the legacy of a Muslim, even no matter the relationship between them in that way. But having said that, this is about inheritance, remember. This is about inheritance. If a Muslim writes that they want to give a non-Muslim for any good reason part of their estate, they are allowed to. They are allowed to, but that is a gift which is at their discretion. No more, preferably not more than 1/4, but allowed up to 1/3 within that scope which they have to deal with their property. So that is something that I hope will answer some of the questions that or concerns that some of us may have. So you can't inherit, but we can give to institutions, you can give to people, you can give for public benefit. So there is no hindrance in giving to a non-Muslim, whatever the relationship is, in the will part, rather than inheritance, as it were. But the others, like I also mentioned, I mentioned last week, include the illegitimate child. An illegitimate child cannot inherit from the father, but the illegitimate child inherits from the mother in Islamic law. So the other one is less mentioned, but it's happening a lot now, a lot. That is a disclaimed child. And how can this happen? So we have an explosion these days of zina, of extramarital affairs, of people who are giving children to, of women giving children to mothers who are not their children. But there are also another dimension that we may have noticed is emerging, where the mother and father, or the woman has not been unfaithful, for instance, but the child has been proven to not be their child. It may sound like Nollywood movie, but it is now becoming a cause for concern that children are swapped in hospital. A woman wants to have a male child and she has had a female child, and people are swapping, or they have swapped a child that is a male for a female, only for that to emerge. So there are things happening these days. May Allah save us. My point is, and this is the major one I want to talk about, the first one. My point is, anyway, that a disclaimed child under the Sharia does not inherit from the father. Meanwhile, the father may have actually made a will in which this child is known and had been mentioned previously as the child of the father. And if the father subsequently disclaims the child but doesn't update their will, and that is something else that I hope somebody will remind me about, we should mention when we come to will making. You don't make your will and put it on under your bed forever and ever. Amen. No. Actually, a will is something that you refresh from time to time based on your changing circumstances. A new child has been born, one had died, Falias will be alive, but this happens. Couples are now divorced. One of the beneficiaries have died. You are no longer pleased with a particular gift you wanted to make. You have acquired more property. So let's talk about the more positive aspect. You've acquired more property. You are a millionaire now, you are a billionaire. And you want to readdress the gifts you are making or wanted to make. So that is something that we should keep in mind when we talk about practical issues about a will. But in Islam, a child that the husband says is not my child, and they've gone and done the process of li'an, that is the process of disclamation, where the father said, the mother says, no, the child is yours. Father says, no, it is not mine. There is a process of declamation of paternity in Islam. It's called li'an. And if that happens, that child cannot benefit. It's no longer a heir of the father. It means a heir of the mother. But it's a very serious issue. And it's not to be taken lightly that you can just wake up and say that this child is not mine, because you are then accusing your wife of adultery. And that's a grievous thing in Islam. But our topic is not li'an today. I just wanted to bring that up, that the child that is disclaimed also becomes the same as an illegitimate one in Sharia for purposes of inheritance. In terms of distribution of the property or the inheritance, the estate, Islam, we must first remind ourselves, made a historic change in human history. I say this very boldly, even under common law, the females did not have a right to their own property, and they were inherited as in some other African culture. At some point, they were inherited as property. If you have read, if you are my generation, and I believe that most of us here, there will be my generation, there may be a number of us that are older, but I think most of us are my generation. I want to assume. If you are my generation, you are likely, if you did literature in English or English literature, let me see, whichever it was you did, you are likely to have read a book called Tess of the D'Urbervilles, Tess, Tess of the D'Urbervilles. I'm sure Alhaji Abdul Razak Ashaju read it, definitely. If you have read it, it is telling you the state of the law in the UK until towards the close of the 19th century. This same UK that we say that these are the developed, civilized, whatever names we choose to call it, liberal, democratic, developed, whatever West. Under common law, a woman was still not having a right to property, and she could not inherit from her husband or her father. She was chattel, C-H-A-T-T-E-L, or C-H-A-T-E-L-L, chattel. She was property. She herself was just an item, a woman. Females, they could not inherit until 1880. That is less than 200 years ago. Whereas Islam brought a revolution. So when people say, Muslims, because of ignorance, we feel inferior, that with an uncivilized Sharia is, what is it, barbaric? Who? Barbaric? Who is barbaric? Sharia law made women inherit, own and be able to inherit 1,300 plus years before it was recognized for women in UK. Common law. Civilized climes. Yes, that's what we use. Civilized climes. And in Africa, in the Middle East, in Spain, in parts of what was the Soviet Russia republics, up to China, parts of China, Islam had legislated the rights of women to own property 1,300 years ago, precisely. 1,300 plus years ago, 302 years before it was recognized. Can you imagine how many generations? Why? If you look at Quran Surah Al-Nisa chapter 4, verse 7, Allah subhanahu wa ta'ala says, لِلْرِجَالِ نَصِيبٌ مِّمَّا تَرَكَ الْوَالِدَانِ وَالْأَقْرَبُونَ وَلِلنِّسَاءِ نَصِيبٌ مِّمَّا تَرَكَ الْوَالِدَانِ وَالْأَقْرَبُونَ مِمَّا قَلَّ مِنْهُ أَوْ كَثُرَ نَصِيبًا مَّفْرُوضًا. Allah said, for men, it's a share of what the parents and close relatives leave. And for women, it's a share of what the parents and close relatives leave, be it little or much. An obligatory share. Nasiban mafruda. You know, Farj prayer. You use the word Farj prayer. Zuri, Asri, Maghrib. And that's a mafrud. It's an obligatory one. It's not discretionary. And about when we finish, if there's anything, we give the women. No. It sets out that first it confers the right of inheritance on women. Another part of the Quran, he said, لِلنِّسَاءِ نَصِيبٌ مِّمَّا كَسَبَتْ وَلِلرِّجَالِ نَصِيبٌ مِّمَّا كَسَبَتْ وَلِلنِّسَاءِ نَصِيبٌ مِّمَّا اكْتَسَبْنَ. So men own what they have worked for, women own what they have worked for. This is what Islam said 1,400 years before, and we are still struggling today to give equal rights to women in the workplace. And still here in the UK, we have legislation struggling. There is legislation, but the practice is still far away. Struggling to ensure that for the same job, lecturer A, women and men are paid the same salary. Security guard, male, female, they are paid the same salary. Civil servants on this grade, that same level, pay the same. There is still a big thing about it, whereas Islam already legislated for that. If you do have cause to work as a woman, if you do work as a woman, you should earn the same as the man for the same kind and type of work. This is Islam. So who is civilized? Which law is civilized? Because there is always that second-class mentality that colonialism has brought to the Islamic world, to the Muslim world, that Western is civilized and Islamic is uncivilized. Unfortunately, our cultures in each one of our countries, as the West has also carved them out for us, in each one of our countries, our barbaric cultures, to be honest, in some cases, our barbaric cultures, not Islamic law, have overtaken our practices of Islam. And so it is when we then look at Muslim countries and Muslim societies, we then find the operation of barbaric practices in truth, but not from Islam. Barbaric practices like honor killing, barbaric practices like punishing and jailing women who have been raped when the rapists go free. Why in the first place should the rapists go free? And then why are you punishing the victim? These are barbaric practices, which then makes us feel confused with what the Islamic position is, as it were. But my point really is, in terms of bringing a historic change, which has then been followed by other legal systems, Islam legislated that women should have the right to inherit. That's a revolution in human history. And in terms of actual distribution, the Quran talks about this a lot in Surah Al-Nisa, but I want to just look at Surah Al-Nisa verses 11 and 12, because they contain what I call golden rules, not all the rules. We'll have time to only talk about golden rules of the distribution of inheritance. So this is just about opening our eyes to fundamentals. Like I said, it's much wider than what a lecture will do. And since we just want to understand this in relation to will making and basic, understanding on how we are going to expect our property to be dealt with and how we will deal with it ourselves while we are alive, it's only going to be looking at, as I did on rules of inheritance, I talked about foundation rules. This one about distribution, there are golden rules captured in verses 11 and 12 of chapter 4. Allah says, A'udhu billahi minash shaitanir rajim. Golden rule 1. Lilidhakari mithlu hadhil unthayain. This has been a source of contention. I'm a professor of human rights, actually, myself. So I know about this probably a little, as it were. I know about this a little. I'll put it like that euphemistically on the controversies around this. But remember the starting point, that women had no rights, and Islam instituted that right of inheritance. That women had no status to own property, and Islam instituted that. And now we are faced with what those who then copy that system come back to tell us is barbaric, unequal, and all of that. I won't go into that because it's not about comparative. It's just about what Islam says. Allah said for the male, what is equal to the share of two females? Now, Islam deals on its own terms. This is the point. That is why, and those points and those terms are comprehensive and need to be understood comprehensively rather than the predilection to pick one verse, pick one thing, like those who say, while somebody who was being mischievous, or at the time, I remember when we were in university, people were being mischievous, and they went to the Surah Al-Ma'un, and Allah said, woe on those who pray. This is not the first verse, it's not the second verse, it's not the last verse. It had verses before it. It has verses, 2 verses at least after it, 2 verses at least before it, if not 3. And they just picked that. Allah said, Wailul lil musallin. You know, Allah said, woe on those who observe salat, who pray. And they distributed among Muslims. You people are going to the mosque to pray. Allah, and your book says, woe on those who pray. They didn't read that the same book who says in 77 places at least that you should pray. So why would he then say, woe on those who pray? But they extracted it, and it was very funny because the next verse says, Alladhina hum an salatihim sahun, but are not mindful of their prayers. Alladhina hum yura'un, they just want to be seen as praying and believing. And they don't even do the smallest kindness. They deprive those who need even small kindness because they are deprived. They deprive them, they don't help them. This is what the verse said. So they extracted it and ran. The same with Lilizakari Mithul Hadhil Umfayain. Where are those people who are criticizing this from coming from? When first, as far as Islam is concerned, and no apology, you and your property belong to Allah. If that is the case, then you have no proprietary right to determine how it is to be dealt with. You are a trustee of your property. And as a trustee, there are rules guiding what you can do. If you are a trustee of the property and Allah is the owner, and he says, give everything to the female or give everything to the male, who are you to query that? It's either you agree to be a trustee or you are not a trustee. That's why I said the first issue here is to go back to understand. And that's why I started where I started, that the property belongs to Allah. You yourself, you belong to Allah. And to Leru, Lo Leru, who are you to query that? That is the first thing. But, okay, if you go further, you then go to the point I made. Women had no rights, even under the civilized system that we call it, to own, say less of inherit property. If you have no right to own property, you can't inherit it because then you need to own it. But women were actually inherited. Read the story of how it was in this Western culture, specifically in what is now the UK. Read the story in the book Test of the D'Urbervilles. It's a 300 or 400 page novel, as it were. Read it there. It sets out the problem of Tess and how she couldn't inherit because of the society in which it's not fiction. It is fiction, but it's depicting society then, as it were. So that is the second point. The third point is, well, this is all within a society where women have privileges over and above that are available to men, contrary to what those who don't know or choose to assail it think or know. But that will be too much of time spent if we go into that. But that is the context. The last point word is just to say that the male who is inheriting twice than the female actually ends up with less than what the female who is inheriting half will have on their hands, because this male will be a father, will be a husband, who at some point, if he's not already a husband, and what he owns belongs to the family because he has to provide. His wife or his sister, who is then, if his wife is getting property from her father and our own property anyway, whatever way she comes into it, belongs only to her in terms of when she is alive. It belongs only to her. So when it is said that the man should have double, the responsibility required in Islam is being considered by the same Islam that has given him that responsibility, and it should be unjust otherwise. But that's where that is coming from, just to put it in context, because usually there's some unease around that, but we need to know where it's come from. The issue is whether we gain the benefit as men and do what we expect to do with it properly. The next point then to go to is the way these rules of inheritance operate. And hopefully I'll be able to show us a website that can make it a little more graphic for us. When we are talking about the shares that will be inherited by the heirs, note at this point that largely I've stopped speaking about wills, which we'll go back to at the end. I'm talking about inheritance. When the husband dies, where there is a husband and wife, I already talked about primary heirs last time, and primary heirs, husband and wife, parents and children. Once these people are there, nobody is automatically able to inherit. There may be a leftover that could be given to any other person outside that cycle as a relative. But if the husband is there, or parents are, and the parents are there, anybody relating to the deceased will relate to them through these parents, or will relate to them through their children, or will relate to them through marriage. All of those people are blocked because of the presence of the primary heirs. So you need to remind ourselves of that. That's what I'm looking at here now, part of the primary heirs. Inheritance of the husband and wife. When the husband dies, there could be different scenarios. If the husband dies childless, the wife inherits a quarter of the property. This is very important, especially in the context of our Yoruba Ori-Ojori practices, whatever called thing, Idigi or Ori-Ojori. The wife has a share in her husband's property. That share is 1/4 if the wife has no child. You know, it's unfortunate how it is then that it is a wife that Allah has decreed had no child for the wife, for the husband rather, that as a couple, they had no children, that has the most problems in our society because of our cultural practice. So may Allah save us, because we move. We are Muslims, but when it comes to certain things, we then move away from the Islam to do some practices that are not Islamic. May Allah save us from that. It's a kind of hypocrisy. The couple have lived their lives as Muslims. There are people and there are couples who, because they have just come about as those that Allah has decreed will not have children. And there are people like that. May Allah have mercy on them. It's a very hard thing. But by Allah's design, they will not have children. When the husband dies, yes, especially the husband, it's not the problem with the wife. When the husband dies, the family then pounces on the property. This is why you need to make a will, not because you are childless anyway, but this is why a will is very important. The family pounces on the property and throws the wife out. Oh, or this wife is one of two, or is a co-wife, has co-wife or co-wives, and then she ends up empty. After 30, 40 years, she may even be the first wife of the husband. And because Allah has decreed that she will not have children, maybe the husband even has children from another wife, or has a child from another wife, she stands the risk of being thrown out, or something, or whatever we say. May Allah save us. But for the avoidance of doubt, if the husband is childless, if there is a wife, the wife inherits 1/4 of the property. Sorry. Yes, the wife inherits 1/4 of the property. And the remainder is for the remaining heirs, as it were. Now, if the husband is survived by a child or children, the wife inherits 1/8 of the property, not 1/4. You see, when we start thinking about how Islam has developed science, technology, mathematics, physics, one of the basic things that had happened was, because of these fractions, Muslims had to work out and become experts in fractions. Ilm al-Faraid needs algebra. As the name Al-Jabbar is Muslim, it's because of these indications from the Quran that we need to move beyond just reading the books to having to work out. In the days when there weren't calculators, this is how Muslims contributed to knowledge based on the Sharia. Allahu Akbar. So the wife inherits 1/8 if of the property if there are children, and the remainder there also is for the remaining heirs, for the children and whoever are those heirs. Now, when it is a wife that dies, remember my golden rule, Lili Zakari, Mithlu Hadhil Unthayayin, for the male, two shares, where there will be one for the woman, double the share of the woman for the male. When a wife dies and the husband is childless, when the wife dies rather and is childless, the wife dies and is childless, not the husband. I talked about the husband now. When the wife dies and she is childless, the husband inherits half of the property. So if it was the wife, she will inherit 1/4. The husband inherits double of 1/4. That is half of the property. And others inherit the remaining half. But if the wife is survived by children, the husband inherits 1/4 of the property. Remember, I said the wife would inherit 1/8 of the property. Because of the golden rule, Lil Zakari Mithlu Hadhil Unthayayin. This is it working out in practice. Then the remaining will be for the other heirs, as it were. Now, I've mentioned to us that in Islam, contrary to the way we sometimes think about these issues, there is a recognition that the father may still be alive. In some cases, the grandfather may still be alive, and the deceased has died and has left property. And we only typically think downwards. We think of the descendants rather than the ascendants. But in Islam, thinks about the ascendants as well as the descendants. Why? Because the person will not be there without those ascendants. And just like the descendants will not be there without that person being their own ascendant. And if you look at it, just as for instance, young children of the deceased, who is maybe the breadwinner, in the normal circumstances, requires care, so do the elderly parents. They are like children in that way. And Islam is a deen of yusr. Yusr is a deen of ease. Yuridullah bikum al-yusra wala yuridu bikum al-usra. Death is already a pain, but Allah wants ease for us. And because of that, it's the reality is that two things hit the parents when their children die. The fact that this parent is either looking at this child may look after me if the child is still young, if the child had grown older and be successful, whatever they could have become, or when they are already, the child has actually come of age. Parents have actually, of course, become more aged and they have retired. The parent is hit by two things. They are hit by the loss, the emotional, irreplaceable emotional loss that constitutes. May Allah save us, because children, as mentioned in the Quran, and even grandchildren are a major source of happiness. May Allah make our children and our grandchildren and our offspring a major source of happiness for us. They miss that, but they also immediately confront destitution in some cases, that they may also not have anybody to care for them and their basic needs at the time they need it most, financially. Not talk about the emotional one. In fact, there may be some people who are their brothers or sisters, but maybe they are not the breadwinners or the major contributor to the welfare of the parent. And even though they are there, the major source is gone. So Islam recognizes that giving shares to the parents will bring them some succor. So they are primary heirs. And we can't shy away from that reality that they will be hit by the financial loss if the child was providing for them. So the father or the paternal grandfather, if the father is dead, if they are now alive when their son is dead or their daughter is dead, as the case may be, if the deceased has a son or grandchild by the son, then they inherit 1/6 of the legacy of the child. I talked about the wife inheriting 1/4 or 1/8 if they have a child. But if they are, because of that child, the father of the deceased will inherit 1/6, because Allah said, "Wali abawaihi likuli wahidi minhuma sudus mimma taraka in kana lahu walad." If there, and for one's parents, to each one of them is 1/6 of his estate if he left children. Okay. And then they inherit the father, not they, the father inherits the remainder. I'll come to the mother. The father inherits the remainder of the estate when the child has left no descendant, has left no child at all. فَإِنْ لَمْ يَكُنْ لَهُ وَلَدٌ وَوَرِثَهُ أَبَوَاهُ فَلِأُمِّهِ ثُلُثٌ. Allahu Akbar. This is part of how the Sharia made Muslims work out what became known as algebra. Look at this wonderful verse, this wonderful part of the verse. It's still one verse, Quran verse, chapter 4, verse 11. Allah said, but if he had no children, if the deceased left no children, and the parents alone are to inherit from him, he has left no children, then it means, and he has no wife, or even if he has a wife, actually, he has a wife and she has taken, and she will take a share, 1/8. Allah says, but if he had no children and the parents alone inherit from him, then for his mother is 1/3. Actually, this is the person having no children, no wife, nothing. He has died, whether male or female, but they have a father alive and a mother alive. Allah says, but if you have no children and the parents alone inherit from him, then for his mother is 1/3. Allah did not say his father. Allah said his mother. So why am I saying that the father inherits the remainder? Because Zakari mithlu hazil unsayain at the beginning of that verse. If the mother is taking 1/3, the father takes 2/3. 1/3 and 2/3 gives you a whole, as it were. Okay, so Muslims have to figure that out and represent it in numbers, in figures, in fractions. Now let's look at the mother, which is already half of the discussion that I will add on this. If the deceased has a descendant, male or female, then the mother will inherit 1/6, just like the father. This is where it is interesting. The initial rule is this person has children. If they have children, the parents would take 1/6 each. The rule of male taking twice of female does not apply. And the reason for that is Allah's wisdom. وَلِأَبَوَيْهِ لِكُلِّ وَاحِدٍ مِّنْهُمَا سُدُسٌ مِمَّا تَرَكَ إِنْ كَانَ لَهُ وَلَدٌ. Allah said, and for his parents, both of them, to each one of them, for the avoidance of doubt, is 1/6 of his estate if he left children. So the same verse that awards 1/6 awards to the father, awards 1/6 to the mother if the deceased has left children behind. Okay, and I've said that if the deceased has not left children behind, then the mother takes 1/3. And that rule also applies to the grandmother, whether they are paternal or they are maternal. They are, and where the mother is not there, but there is a grandmother, which you can imagine would be even more in need, then they are also entitled like the mother, because they step from where they are, they move down to become the mother, as it were. And in that situation, and it's not surprising, because you find also that in reality, where people have lost their mother probably usually early on, they probably have been taken care of by their grandmother. And Allah has already designed that there is some recognition of this. If the grandmother is there to step, they have acted as the mother, those that step into the rights of the mother in toto, to use that terminology. And they also will inherit 1/3 if the deceased has no child, just like the mother would have done if there was no child. فَإِنْ لَمْ يَكُنْ لَهُ وَلَدٌ وَوَرِثَهُ أَبَوَاهُ فَلِأُمِّهِ ثُلُثٌ. So the same verse applies there to grant a further share or a larger share to the mother. Now, the next rule of distribution that I wanted to talk about is the rule of the agnate relative. That is a person descended from the same male ancestor of the deceased, whether that is full blood of the deceased or not, but from the same male ancestor. They have a right of arad. That is something that's returned to the estate, as it were, because the shares have been exhausted, but because of those fractions, 1/8 here, 1/5 here, 1/3 there, 1/6 there, 3/19 there. If there is a portion that is left, then this goes to the closest male relative of the deceased. The closest male relative of the deceased that has descended from the same male ancestor. Again, why is this? It's for the same reason that in Islamic society, it's expected that the male have a duty to take care of their females. And the females are able to hold on to their own property, even though they can also spend it in the way the males can spend theirs. They are not obliged in the way the males are obliged, first and foremost. We find in Sahih Bukhari and Muslim that Prophet ﷺ said, give the fara'id, that is the shares of the inheritance that are prescribed in the Quran, to those who are entitled to receive it. Then whatever remains should be given to the closest male relative of the deceased. And to put that simply is that it is anticipated that the females, directly or indirectly, will benefit from the male who has been given the right. Because if there are females who are in need, one of the first points of call should be to the male of the family. And in the case of the husband-wife relationship, to the husband, as it were. So let's move on then to the principle of unlawful exclusion. We cannot, as I had said, this would take only a short time because I had mentioned it earlier. We cannot, through a will or the act of executors, the executors cannot, and the testator cannot, through their will, exclude someone that is a lawful heir of the deceased. Because Allah subhanahu wa ta'ala says, وَمَا كَانَ لِلْمُؤْمِنِينَ وَلَا لِلْمُؤْمِنَاتِ إِذَا قَضَى اللَّهُ وَرَسُولُهُ أَمْرًا أَنْ يَكُونَ لَهُمْ خِيَارَةٌ مِنْ أَمْرِهِمْ وَمَنْ يَعْصِ اللَّهَ وَرَسُولَهُ فَقَدْ ضَلَّ ضَلَالًا مُبِينًا. Allah said, it is not fitting for a believing man or woman, when Allah and his messenger have decreed a matter, to have any other choice in that matter. Indeed, whoever disobeys Allah and his messenger has clearly gone far astray. So this answers the question, what do we do when someone who is a heir has not been dutiful as a child, for instance, has not been dutiful to the parent, and some others have been dutiful? You leave that to Allah. You leave that to Allah, subhanahu wa ta'ala. The person is not to be disinherited because of it. And all of that. Well, there is no concept of koinyolomo in Islam, and there is the concept of koinyolomo in Islam. The concept of koinyolomo in Islam has to do with if it can be established that the child is not that of the parent. Lian has to be done. Okay, in that way, yes. But if it is that because the child is misbehaving, and then you now go in your will and write, it's no longer my child. You can't do that. Simple. You can't. Your will in that part of it is ineffective. And the executors must not. No, you are only perpetuating a sin. In fact, if you want to help him, you must ensure that that child is given their lawful due. This is a very important thing. So you cannot deprive somebody of their right. That's just it. You have to give the right of people, you must give people their due rights. It's a principle of the Sharia. Prophet ﷺ said. So, just to put that to rest, as it were, the last bit I said is about some practical issues around making a will, which I'm sure by now, many of us are anxious about if we've not made our will, or probably we've even made it in some way. And now, having listened to our discussion this far, realize that we need to make some adjustments. Okay. So the first point I wanted to make is that, in my view, considering all we've said, a will is now a necessity more than ever for Muslims. And there should actually be an explosion of will making amongst us. And this is the case, especially for Muslims everywhere, but especially for Muslims living in the West, but also for Muslims living in Nigeria, because part of the rules of the West apply in Nigeria as the dominating, not the only legal, but dominating structure. So there is recognition of non-Western laws like Islamic law and what do we call it? Customary law, as it's called in Nigeria. But these legal structures like probate is dominated by certain rules that are derived from UK common law and practices. We need to ensure that we make a will and then make the will one that can be enforced. Somebody said at this forum or last time that, how do we do this when Islamic law is not recognized, or Sharia is not recognized, as it were? And I said, oh, if there is anybody who says that Sharia is not part of Nigerian law, it's just untrue. That's the kindest I can say about the person. And I would like to leave it at the kindest. It's just untrue. If there is one aspect of Islamic law that is not a question of, oh, where is hijab written in the constitution, that Muslim can use hijab or not, and all of that, whether you need that to be explained through a court or of law or not is a matter of debate. But one that is not a matter of debate is that in the Nigerian constitution, there are provisions, the basic major provision that is mentioned in relation to Islamic law is the law of personal status. And not only is it recognized and stated in the Nigerian constitution, 1979 is the operative one, as amended. It is also the case that in the structure of the federal courts, not to talk about the northern states, in the structure of the federal courts as provided for by the constitution, Islamic law is recognized by in the composition of the courts, in the appellate courts, not necessarily in the high court. So in the Court of Appeal, the constitution requires a number of judges to be appointed based not only on their legal qualifications in common law, but specific knowledge of Islamic law to deal with the provisions on personal status, which the most important of which is the one regarding will and testacy and intestacy. So it's not correct that you cannot make an Islamic will in Nigeria, or that you cannot say you want Sharia to be the system for distributing your estate. It's actually recognized in the constitution. The Court of Appeal has to have judges, and the Supreme Court has to have at least 3 of 21. And since they created it, this is the first time they I think they have 21. I don't know now if they still have up to 21. That they tried to have 21, I think, the first time. But whether they had 21 or not, whether they have 17, 16, 15, 14, they are required to have 3 people appointed to that court on the basis of additional qualification, on the basis of Islamic knowledge of Islamic law at any point in time. Again, for the purpose of carrying out the intention of the Constitution that Muslims' personal law on dealing with property, including will making and intestacy, applies, and the distribution of Muslim property. So that is something I want to leave beyond doubt. It's just that you need to pay me to show you this section of the Constitution. But if we go online now and check online there for Nigerian Constitution, you will see about the law of personal status and the provisions relating to these issues. We are professionals on the forum, and I challenge us to do that ourselves, as it were. But if anybody is in doubt, if they have read the Constitution and don't find it, let them write to me, and I will charge them before I show them the path. But it's there on a serious note. So please don't shy away from, oh, how can I make a will that would not be enforced? It's enforceable in Nigeria. But for those who are in the West, there's a further complication. For instance, in many Western countries, but definitely I can talk about the United Kingdom, where depending on how rich you are and your wealth gets to a particular threshold, right now is more than £500,000. If you don't make a will at all, Islamic or not, if you don't make a will, you would be liable to up to 40% of your estate, going to the government, Her Majesty's Revenue and Customs. 40%. That will be so bad. Okay? And if you don't make it in Nigeria, and they have to take out what is called letters of administration, which is what will be taken out here too, to distribute your property. These are the jeopardies you suffer, that you have not appointed people you want to distribute your property and take charge of the estate. So there will be a scramble as to who can do that. Whereas if you have appointed your executors in your will, you will not suffer the delay and the cost of obtaining the letters of administration. You just get the will to probate, i.e. being certified because it has been deposited at the point that been made and all of that, and being allowed to execute the will. And by the way, when you do make a will, you can actually consider making one trustworthy heir one of your executors. A husband can make the wife, a wife can make the husband one of their executors, as it were. If you have grown up children, you can make one or even two of them, a male and a female, one of your executors or two of your executors. You can have 3 executors, you can have 4. It's not the most advisable to have 1. But all of those issues, you will have to meet your lawyer to discuss them. I'm not here to talk about them in terms of specific details, but just to throw out those things that we can think about on what it means, what you are looking to do when you make your will, and how to try and put in place mechanisms to ensure that your will is distributed, your estate is distributed to those who should get it, and in the way you want. And also I mentioned, I think in the last in the first lecture that one of the most important things you also want to do with your will is to set out your assets and your liabilities, because if you don't put your liabilities, then if your will is distributed, it may be difficult to meet the liabilities, but the liabilities must be known and settled first before the assets. The other thing is that, so we are not in the UK, so I wouldn't even bother us with interstate rules here. But the other thing is that under the Islamic laws of inheritance, despite the trepidation that people have, we can use Western legal systems to implement the provision of Islamic law in most Western legal systems. I don't know what the situation is in France, which has shown a lot of hostility lately to Muslims, whether they have gone to the extent of making a specific law against it, but otherwise, whether it's in the UK and certainly in all common law countries, which many Nigerians are in diaspora there, whether it is US, Canada, UK, Ireland, probably there are now a few of us, I don't know, in New Zealand, and I suspect more than that in Australia. Those legal systems can be used to accommodate the implementation of your Islamic will. You just need to set it out that that's what you want done. The other point, and back to Nigeria itself, if we leave our property to be distributed without writing a will, because we are either afraid that writing a will means I will die. See, if you write a will, you will die when you will die. If you don't write a will, you will die when you will die. But if you don't write a will, you are leaving your people, your heirs in problem. And if we have not noticed what Allah had stated in the Quran 1,400 years ago, then it will be a strange thing indeed that if you have not noticed how it's worked out in our country. And I tell you, it's the same here. With the same set of circumstances, if the same set of circumstances come in, i.e. that person doesn't make a will, the worst is brought out of people who are wanting to, who are either the heirs or claiming to be the heirs of the dead person. Property left behind causes the greatest acrimony or ogun. Look at it in our society, in Western Nigeria, Boromiro, Office of the Public Defender, or Office of Mediation. What is the largest, what is the biggest issue that they deal with, these mediation mechanisms? It is about estate. It's about estate. What divides the family most, whether it is one of the biggest lawyers that the country has produced, or a notable Nigerian, okay, who was well known nationally, continentally, and internationally when they have died, even where there is a will. What has brought acrimony? It is this issue of property distribution. And Allah warns in the Quran about it. He said, look, those who are going to even be executors can be a problem, but they should fear that if they are in the position where they have left children who are orphans, who are young, who need to be taken care of, what they will expect or pray to be done by their orphans is what they should do when they are appointed as executors. And one of the points that I wanted to even make here is that the practice out of fear or some cultural understanding is not to tell anybody you made an executor that you should tell them when they are alive. It is important. You may think that this person will be able to stand up to the duty, to the job, and you tell them that, and then you die, and they say, I can't stand up to it. This happens maybe 1/3 of the time. They are not even going to be bad people or anything. Just say, I can't. No, I can't. So you should tell your proposed executors that you want to make them executors of your will. You should. Whether they are older or younger than you, you should tell them. Allah knows. You don't die necessarily by older or younger. There are many people on this, all of us on this forum, there isn't somebody that is younger than us, that doesn't have somebody younger than them that has died. Somebody their age that has died, and somebody that is older than them that has died. So it is a farce to say, because the person is 1 year older than me or 2 years, so that means, are you saying that you died before me? No, these are just drama. If you think the person, irrespective of whether they are older, if you think the person would be the kind of person you would like, it's useful to tell them so that you get their consent and understanding that, oh yes, fine. Alhamdulillah, I pray I don't. And because, again, they may have died, and when you say they may have died, the person who left the will may die today, and one of the executors may die tomorrow, or even a few weeks, when it's not even time to really execute anything. You make sure that you don't make one person or even two your executors, if preferably 3. Then, like I said, think about making somebody, if you are satisfied with their conduct, one of those people who is going to benefit from the will be an executor, along with others who can ensure that the right thing is done. Okay. So the other point which I had made earlier is that you should comply with the law of the country. You must make sure that you don't write your will and put it inside an envelope under your bed and say, I've written a will. If a will is accepted like that, maybe in Saudi Arabia, I don't know. But if a will is accepted like that in maybe a Muslim country or another Western country, in Nigeria, if it is contested, there may be a problem, or in any other country. That's one. 2, it's not even clear that when it is then time to dispose of the property by those who have inherited them, if the will has not been taken to probate, i.e., has not been deposited in the court. The lawyers know all of these things. That's why I say you need to involve a lawyer. Has not been made in compliance with the rules of that country as to who you can choose as an executor, and after you've made the will, how you sign it, who is to sign it, and all of those things. Oh, and by the way, one of the things I quickly want to disabuse our mind about is that typically your will will be made in a way that the executor will see the document but will not know its content. So it's not like, oh, that means that that person will come to know everything that I own. No, they must be there. You sign it, they sign. Oh, that is the document. And so your privacy is not necessarily breached by it. If you want them to know, I had somebody who said to me they wanted me to be their executor. I said, fine. And then later, it was after listening to a lecture like this, and then later they sent the will to me. And then I said, no, you shouldn't send the will to me like that, because it was virtual. We just need to be in each other's presence when you are signing, and we have to find a way for me to also sign. But I don't need to know the contents of the will until it's time to execute it, if Allah destines that I will live to be your executor, as it were. So those are some of the trepidations we may have, but your will is a very private thing, and it is kept private in that way. So that doesn't mean that the executor will know everything about the will, except that there is a will and they have signed, and it is the document they signed that is then presented later. And of course, I've said nothing in the will should be contrary to Sharia. You can't give, for instance, I'm giving 1 million pounds to buy a bomb to bomb all the people in XYZ country or city. You don't do that. That is not allowed. But that's an extreme example. You cannot also say that I'm giving out this money to develop a new breweries to brew fine wine, alcoholic wine in pursuit of science, as it were. You cannot do that because production of alcohol is contrary to Sharia, for instance. So before I conclude, there is something I hope I'll be able to share that may be of interest to us here. Sorry, I hope I had tried this and it worked. I'm now hoping that it will work here. Yes. Can we see this? ShariaStandards.org. Can everybody see this, please? Can you see it, host? Brother Demola?
Not yet, sir.
Oh, not yet.
We are only seeing your slides.
You're still only seeing my slide. Huh.
Yes, sir.
This is my fear.
Conclusion.
Conclusion, that's the only one you are seeing. I have actually opened a page on the internet. Okay, let me see. Maybe I will stop and share it. Maybe I'll stop. Yes, okay. Now you should be able to hopefully see this in a few moments. Can you see it? We have seen it. You have seen it. Thank you.
Yes.
So, for those who don't know or may not have access to the slide, let me try and let me put this link in the chat box. That's a problem. How do I get back to the chat box now? For a moment. Okay, I'll put it in the chat box subsequently. I hope you can see this. Now, this is part of the efforts of some brothers, which is to be commended. They call it ShariaStandards.org, developing a global open standard interpretation of Islamic law in English. This is where we can see how some of the fractions that have been mentioned, works out. So can anybody, I want 2-3 of us to give me scenarios which can occur after somebody has died. But I will start, just for you to know what I have in mind. I will start by trying to show of somebody who is deceased now. Please, let's see if this works. Somebody is deceased, okay? And they have left property that is to be shared. We are assuming that this person, the obligations they have been taken care of. They have already, their debts have been paid. The person has been buried, their debts have been paid. Whatever specific aspect of their property through the will that they have mentioned they want to be disposed of has been given away. The person is a male. Okay? This first example, the person is a male. I hope you can see it better now. The person is a male. Can we see it better? Or have I lost you there? Because I can't see the borders again.
We can see, sir.
Okay, good. So the person is a male. I want to distribute the party there. Good, thank you. The person is a male. Okay, this brother has died. And you see, gender of the deceased, male. Primary heirs. The person has not left a father. No, the person has left a father. Let's see how it works out. He has left a father. The mother is alive too. The person has left a son, and the person also left a daughter. Now, the person had a wife. They had one brother, and they also they have one brother and one sister. So look at this brother, he's died. Unfortunately, he died at 60. His father is 85, is alive. His father is alive, 85. His mom is 80. He has one son, 42 years. or 40 years or 35 years. He has one daughter. That daughter is actually older than the son. She is 40, the son is 35 years. Okay, now the person also left one wife, was monogamous. He has one brother and one sister. This is how the property will be distributed. See the mathematics that has been applied in terms of the fraction stipulated by the Sharia. This website has already built the Sharia fractions and allotments there. So once you put in this detail, it just works it out for you. So the blue there is the son. He is getting 13/36 share as a fraction, or 36% of the estate that is to be shared. The daughter is getting half of that, 13/72%. The father is getting 1/6 of the estate, which comes to 16.6%. The mother also similar share. The wife is getting 1/8%. Now, if you work all of this out, let's try and work it out without the smaller fractions in the percentage. Let's work the percentage out. 36 plus 18 gives us 54, plus 16 gives 70. 70 plus 16, 86, and 86 plus 12 gives us 98. Now I know there are some smaller shares there, point, which seems to go, there is 0.6, 0.6, 0.5, which probably takes it to 99 point something, if it is not 100. And it's very possible that it may not come to 100%. If it doesn't come to the 100%, then you will notice that the brother is not mentioned there. And I want to now flip the whole situation. I have been the one talking. We are in a workshop. This is where the workshop thing can actually be where we can actually workshop this session rather than just me talking at you. Thank you for your forbearance. Now let's workshop it. What happens to the less than 1% that is left? You see, he has everybody that I've mentioned have been taken care of, but the brother and the sister do not have anything there. What do you think will happen, should happen under the Sharia? Can you allow participants to be able to respond, please? Either by putting on their mic or indicating to you whatever way you want that done. But I want our engagement, I want answers, because we are going to model this in different forms for a few more minutes before we go to questions. Yes, please. Moderator, how do you want people to respond?
Hello,
Alaikum salam. Yes, please. We can't hear you.
we can take comments from.
Yes, please.
Yeah, Bash, can you go ahead, please?
Okay, Alhamdulillah. From what we have a question on the chat box that relates exactly to this particular sample in which
I see. I'm not looking at it. I've not been able to look at them. The chat box. Yes.
Okay. And that question was asking why the relatives, none of them had a share, or if the relatives are present at the point of sharing, because we've had this a practical session in which the brother was the breadwinner to even his relatives, and he had sons and then daughters and a mother. So, and we know a lot of the family, other siblings are there.
Yes.
So the scholar that actually did that sharing noted an amount for them. So we did not know how we calculated the amount, but from here now, with this sample, I could see that the remainder is what the scholar actually allocated to the brothers to show that they are recognized. So now that's what I'm.
Jazakumullah khairan. That's an excellent contribution. I have nothing to add, except to say that in this example, the brother will take priority. But if, for instance, that brother is well off, it will be very best advice that it can be given to the sister. But as a matter of right, the brother will take priority, or most of it will go to the brother, and then you could give a sister as it were. So I'm very happy that we are able to benefit from the session that you have had and what that scholar said, exactly what should happen. Yes, please. What I want is for people to also think about their own circumstances without necessarily being exact and see how it works out. So I want suggestion for somebody to tell me, I'll go back up there and have another model. It can be male or female.
Assalamu alaikum, sir.
Wa alaikum salam. Yes.
Sorry, before you go ahead, could you please, can we have the response from Alhaji Fashola again? I'm not sure everybody captures that.
Oh, sorry.
For the avoidance of doubt, please.
Oh, okay. Yes, please. Alhaji Fashola, please make that contribution again.
I said there's a question on the chat box,
okay,
which is the normal case that we see around most often. It's a situation whereby when the disease, that's the husband, has a male or daughters, has children. So most times, those children, by what we've heard, will have negated all his other siblings, that's his brothers and sisters in his head. And most of these situations, sometimes the brothers are the breadwinners of all this family, or maybe the eldest of the child of the parent. So, and they are the ones that they call normally Baba Siku, or the ones that the children will live up to or look up to, for so many things. They expect that those people are the ones who take care of the children after the death of their father. So when you do the inheritance, the way you've seen it according to the Sharia, it seems to be no share or anything assigned to them. And this, if this is implemented, it's like a friction may occur later. I'm left with my own to tend for my own children. So, and the one episode that we've actually engaged in practically, I think on H&H level, we had this same scenario, and a particular amount was assigned to the siblings of the disease. So I had been worried that where did that amount come from? Is it a proviso or something? But now from this calculation, I'm able to see that there are some balances left after all the sharings. So I think that particular amount shared out must have been from the remainder. So which is what we saw from here.
Thank you very much. And we'll see more. And like I said, you are right in total. And I'm happy that this has helped to take further a practical experience that you have encountered. There is something that you have just said that reminds me. One of the benefits of making our will is the opportunity, depending on our circumstances, to be able to say, this is the person, and all of these things. The person, first, that I want to be executors, considering circumstances, and secondly, you can actually nominate, as with the Western law, you are actually allowed to nominate someone to be the guardian of your underage children. You can actually nominate someone who could support their mother, for instance, if you wish, in being the guardian, in which case that executor will also be an executor and guardian who will be able to look into it that the share of the child, that child is taken care of, and the share of the child is not dissipated. It's not dissipated or wasted. as it were. So this is something that is important that you can do with your will, and Islamic will too. So thank you for that. Yes, I want maybe the moderator, can you give us a scenario as we go? So I want somebody, I've looked at an extreme case, but it's extreme only to the extent that we don't like and we don't pray. Not that we don't like, we don't pray that this is the situation that the person leaves father and mother. So don't mind me for that, but I just wanted to show something about how it works out if they are there, as it were. Then one thing that also occurred to me is, what did you say?
I said, Assalamu alaikum, Prof.
Wa alaikum salam to. Is that Abrazak? Malam?
Yes.
Okay, sir. What are you saying? Scenario.
What I'm saying is that immediately you finish your comment, we want Brother Said to take the questions on the chat box so that when we address that and there's enough time, we can do other
okay, then.
scenarios.
Okay then. That's absolutely.
And I also want to add, may Allah forgive one of our friends and admit him to Jannah.
I mean,
That about 12 years ago at just 42. But he appointed one of his friends to be the one in charge of the children.
Yes.
And it was not that he was sick. He died the same day he had. So somebody like that, I mean, he was already prepared. This was the fact that he was at his prime and he was heavy and hearty. So you already had somebody nominated that if this happens, let this man be in charge of my children. And today, alhamdulillah, it has been like that.
That is excellent. That's a will. I said it to us, I think, last week, that the idea that a will.
I didn't hear you, please.
Sorry, I said that is a will that he has made. It's a will that he has made, and it's being carried out in that way. It's part of his will. Can you hear me? Hello?
Yes, we can hear you.
And so I'm only saying that is commendable on his part and on the part.
I can hear you.
I said what you have just described is taken under Sharia as a will, that he declared this person to be a guardian, if not the executor of his estate, a guardian for his children. That is part of what we can do in a will. And you can have an executor separate from the guardian, but it can be quite handy that the executor, if you want to have a guardian for young children, they should also be one of the executors so that they will have a say directly in the administration of the estate. But that is part of what we should do. It should be clear, whether we put it in writing or not, that we should all do this and say, hey, Abrazak, if something happens to me, I've told my family, you are the person that will play this role, irrespective of, and it's better also that we are then going to be able to put it down. But the scenario you have painted is something that can happen to any one of us. This death is different from disease. There are so many people that are living, that are ill, that have not died. And there are so many people that have died that you couldn't say, because Allah doesn't legislate these issues or decree these issues in the way that we think about them. So it's a big lesson to us. The person has done well, may Allah forgive him. And the person that has taken on the responsibility, may Allah reward him abundantly. This is one of the major things that we can do to earn paradise. And may Allah put it in the mizan of the good deeds of this brother that has taking up the responsibility, because so in conclusion then, is the same point that I've just said. Death is inevitable. So we should not shy away from making our will one way or the other. And the other issue is the challenge. Alhamdulillah, some people are already meeting it. And that's actually what H&H is emphasizing by bringing for the second time the only topic that is being repeated as a workshop topic. That is very thoughtful, and I don't think it's a waste of time at all. May Allah subhanahu wa ta'ala reward us abundantly for it. But we need to spread this, to introduce and spread the knowledge of Islamic wills and inheritance rules. And I'm not saying that what I presented last week and this week is by any means the Islamic rules. I mean, I'm just reintroducing it and just touching on basics for us. So there is a vast amount of knowledge there. And also because in terms of what Islam says, some traditional understanding of it and what the modern society is now. How do you deal with things? There is a notion, I for one, even as a law student growing up, my idea of a will and everything was basically that you give everything to everybody and all of that. But the way property is now, some of them are fungible properties. Some of them are houses, the traditional idea of property. Some of them are severable. Some of them are not severable. We have to think, what does Islam intend? Does it mean that what about the fact that you have to take care of the property itself and it's part of, you have a flat inside the building and another person, your brother is the owner of the other flat. When we say we are handing it over, do we hand over when we don't think of what do we hand over? What do we not hand over? What does it mean to hand it over? Given that you want that thing to continue to be useful and you can't even separate it. It's not money, it's not cash, as long as we are not selling it, or should we sell it? Those are issues that we have to contend with in the light of Islam being a system that abides forever and the nature of the society we live in terms of how do we deal most beneficially as Islam wants. Remember, it is to make the people get provisions rather than to just be able to dissipate it. Allah knows best. A useful tool is what I've left here, and I have put it now, is what I have gone to for us to see how it works, and I've put it in the chat box for us to access it. I'm sure there are others, but I found this one very useful. I've said what I've said, and I ask for Allah's that you have heard. I ask for Allah's forgiveness for all the errors that I have made, and may He forgive me and all of us. Assalamu alaikum warahmatullah.